If your security clearance is denied or revoked, can you sue the government to get it back? Hi, this is Lenny Kaiser with clearancejobs.com. That's a question we get on a somewhat regular basis. The long and short answer of it is basically, no, you do not have a right to a security clearance, and there is a lot of legal decision-making from the past that kind of has solidified the idea that an individual does not have a right to a security clearance, and that security clearance policies and procedures and determinations fall within the purview of the executive branch. This is in the news recently because there is a former FBI agent, Michael Zummer, who had sued to try to get his security clearance reinstated, claimed that his First Amendment rights had been violated. He had provided some information to the court about a case, lost his position, and lost his clearance eligibility as a part of that. And again, a recent court decision through the Fifth Circuit Court of Appeals, I hope I got all of those right, basically reaffirmed what courts in the past have always stated. Department of Navy versus Egan was a Supreme Court case that kind of bore this out and said, hey, we are going to leave this with the Civil Service Reform Act, Merit Systems Protection Board. It is going to be within the purview of the executive branch. An employment law, security clearance policies will fall under that. So you don't have the same First Amendment protections that you might have for other employment actions or other issues. The security clearance process has been deemed unique and falls under this specific system and falls under the executive branch. So as it stands, you cannot sue if your clearance is denied or revoked. We talk a lot at clearancejobs.com. So if your clearance is denied or revoked, there are steps you can take. You can appeal that decision. If you are fired or lose an employment while there is some pending action related to your security clearance, you typically fall into a loss of jurisdiction status. You would have to get another company to sponsor your security clearance. But assuming that goes through that process, there are some process rights in terms of kind of stating your case or what the issue is, but you do not have a right per se to a security clearance, and suing to get your eligibility back or claiming a First Amendment violation, that you have a First Amendment right to provide information and your security clearance was denied as a part of that, is not going to fly. We do see kind of ebb and flow sometimes. You know, there's criticism of that old Supreme Court case and saying that there needs to be a new update or change in terms of how clearance eligibility is granted and how, you know, the policies around denial or revocation of a clearance are addressed. I wouldn't expect those to change in the near term. When we're talking security clearance reform, there are a lot of other updates or initiatives in the hopper that don't pertain to any kind of court change. But anytime these cases are in the news, including this case of this former FBI agent and suing related to a First Amendment violation, it's always worth following because you never know in terms of what happens with cases, what could get presented and how policies could potentially get changed based on a judicial decision. But for now, the judiciary has said we are out. Executive branch, you are in. So those security clearance policies are going to be born out of executive order set up at the president's directive. We're expecting potentially some changes in classification policies out of the Biden administration. There's been some talk about that. So we'll see executive orders that address the security clearance process, eligibility for classified information, classification guidelines. Again, those all come out of executive order. Thus far, what the courts have said is that you do not have a right to a security clearance, and First Amendment protections around your clearance eligibility do not coincide. You have First Amendment rights, you have rights to freedom of speech, but those just don't tie into your clearance eligibility and revocation decisions based on employment actions. Those are based on executive order. For more on this fun legal jargon, you can visit us over at clearancejobs.com.